We are now live.
Yes. Good afternoon, everyone. We at the Center for Arbitration and Research at MNLU Mumbai welcome you to this webinar on virtual arbitration in India. This is part of the project undertaken by our center around the time of the commencement of the lockdown in India, which began with our publication titled Virtual Arbitration in India, a Practical Guide, and is now being followed by a two-part webinar series with leading arbitration experts. I'd like to invite our faculty coordinator and the research advisor for this project, Professor Chirag Balyan, to tell you a little bit about our center and the guide that we recently published.
Thank you, Natasha. Good evening to all the esteemed panelists and our dear participants. I welcome you all to the e-launch of our recent publication, as Natasha informed you, Virtual Arbitration in India, a Practical Guide. And it is on this theme that we have devised this two-part webinar, of which the first part we are having today. I'm happy to share that in the month of March, when various court hearings, process, etc. were going on, our center, Natasha and Aditya, came with a wonderful idea that we should do something about virtual arbitration because there was lack of information, knowledge, and everybody wants to talk about virtual arbitration, but there was nothing on the basis of which we could take an informed decision. And the major challenge which we realized at that time in embracing virtual process was the mental barrier. We realized that technology generally people are scared of and are feeling very hesitant about it. So there were concerns, skepticisms, but also at the same time there was a hope. And to discuss these concerns, skepticism, and hope of the present and future of the virtual arbitration, we prepared this guide, which basically discuss first technological issues. What kind of technology can be used in the virtual arbitration? What that technology has an implication on the procedural and the substantive rights. We have emphasized in this guide that case management conference and pre-virtual arbitration agreements are going to lead to the maximum efficiency of the virtual arbitration if the parties are apprehensive of the process, taking the advantage of the party autonomy which is available in virtual arbitration. Parties must take benefit of that and must come to consensus during the case management conference, which technology they want to use, how they want to go about taking of evidence, how they want to go about arguments of the case, etc. And that can help them in alleviating the apprehensions which pertains to virtual arbitration. And then the second part of the guide deals with the legal aspects, and there are various apprehensions about the due process concerns with the arbitration. To my opinion, generally there are no due process involved in virtual arbitration, but again, as I said, there are mental barriers. So with that objective, we prepared and we have esteemed panelists, the experts in the industry, to take us through these technological and legal issues. With this short introduction, now I pass on to Natasha.
Thank you, Professor Balyan. Sir has been most supportive of research at our center and has been the guiding force for all our endeavors. Without further ado, I'd like to briefly introduce our extremely distinguished panelists for today. Of course, no words could do them justice, but I shall try nevertheless. Mr. Darius Khambata is a senior counsel practicing before the highest courts of our country. He has held two distinguished public law offices, that of the Advocate General for Maharashtra and the Additional Solicitor General of India. He was the Vice President of the LCIA Court and is currently serving as a member of the SIAC Court of Arbitration. Sir has been very supportive of the Center's efforts as a member of our advisory board, and I cannot overstate how grateful we are for his presence. Mr. Ben Giaretta is an international dispute resolution lawyer, a chartered arbitrator, and a mediator based in London. He's a partner in the Dispute Resolution Department of Mishcon Reya and is the chair of the London branch of the Chartered Institute of Arbitrators. His experience spans a number of industries, and he has represented clients in disputes across the globe. Some of you might recognize him from his extremely thought-provoking posts on his social media. His posts on virtual hearings have greatly influenced parts of our guide. Mr. Sameer Jain is the founder and managing partner at PSL Advocates and Solicitors. His practice primarily focuses on international commercial arbitration along with corporate and tax litigation before Indian courts. He has been appointed as a member of the ICC Commission on Arbitration and ADR in Paris and also forms part of the core committee of ICC's Indian Arbitration Group. Ms. Sonali Mathur is a partner at AZB Partners with an expertise in domestic and international arbitrations. She has represented various clients in complex commercial and contractual matters in a variety of sectors. She is also a member of the YSIAC Council and is a part-time professor at Government Law College, Mumbai. Mr. Vikas Mahendra is a partner at Keystone Partners specializing in domestic and international arbitrations. He has represented clients in a variety of disputes both in India and abroad. Mr. Mahendra is also the founder of our technology partners today, the Center for Online Resolution of Disputes, CORD, an organization that provides online hearing and case management services to conduct virtual arbitrations. Mr. Mahendra often says at these webinars that he wears two hats, one as a lawyer and one as a legal tech entrepreneur, and we can rest assured that he'll be having those hats on today as well. We thank all of you for taking your time out on this Sunday afternoon to address us, and we are sure that the audience tuned in can look forward to an interesting and engaging discussion. I'd encourage the audience to keep asking questions on the chat screen. We have reserved some time towards the end for question and answers from the panelists. With that, the moment is now. We begin our discussion. So, as you all know, the COVID-19 pandemic has compelled the world to reconceptualize dispute resolution in a matter of just a few days. Parties are now being forced to consider virtual options for their disputes. Mr. Khambata, sir, if I may request you to set the ball rolling by telling us what has your experience been? Do you think that virtual arbitration is a feasible alternative for the in-person experience, especially in a country like India?
Yes, Natasha, the answer in one word. I think virtual arbitration or a virtual hearing, whether before a tribunal or before a court, is ultimately having to do the fundamentals better. The fundamentals have always been preparation in advance, clear thinking, concise, focused pleadings and written submissions, getting your case together, limiting yourself in terms of pages and time, and then going about and making that oral presentation ultimately before a tribunal. If you do all of these things better, then the virtual hearing becomes fairly similar to a physical hearing. Of course, there are differences, and there always will be. But in terms of advantages and disadvantages, I don't think that a virtual hearing puts you at any great disadvantage at all. In many ways, a virtual hearing gives you advantages which you hadn't dreamt of. Let's take the one biggest problem in international arbitration. It's the cost and impracticability of congregating tribunals, lawyers, witnesses, parties from all over the world in one place at one time. Miraculously, in virtual hearings, that problem vanishes into cyberspace because, of course, given adjustment for time zones, you can make all that happen quite easily. So this is an advantage. There are advantages also in breaking up a hearing into shorter sessions or shorter periods of time, which gives you space for preparation in between, which you never had if you had to physically meet. So it's a matter of adjustment. And it's like you reach into the past to do things better. It's what, the old Roman god Janus. He had one face looking forward to the future, but the other face firmly set on the past. So you draw from your techniques and practices in the past, you better them, and look forward. And I do believe that virtual hearings are here to stay. I don't think they're going to vanish in 6 months or a year when the pandemic goes. I think there's a huge value to them, particularly in international arbitration. And it would be a shame to lose that value just to slip back into a pure physical mode at the end of it all. So yes, I think it works. As Winston Churchill said, never let a good crisis go to waste. I think we must embrace this crisis and show that we are capable of something good coming out of it.
Thank you, Mr. Khambata. That's a very optimistic note to have started on. Mr. Giaretta, would you agree with Mr. Khambata's experience? Has that also been your experience in the cases that you have been appearing in? And that being said, are there certain types of disputes that you would not advise virtual arbitration for?
Yes, thank you, Natasha. So I'll start by saying I agree 100% with what Darius has just said. I totally agree with it. Now, it's possible that we may see more of a move back to in-person hearings. I am an optimist in this sense, but also a realist. And I think we will discuss later on some of the factors that will move people back to in-person hearings. But from my point of view, I believe that every single case can be done by a virtual arbitration hearing, particularly when one follows the very useful tips and guidance in the practical guide that you have issued. I think it's a tremendously useful publication. I just want to add a couple more advantages to the ones that Darius has highlighted. Firstly, the psychology of arbitration hearings. When I've been in arbitration hearings, particularly international arbitration hearings, there's always a pressure on time, particularly when there are flights for people to catch at the end of the hearing. I've had a hearing where one of the arbitrators on the last day was constantly looking at her watch because she was anxious to get away and catch a flight. That disappears through this medium. There is no more time pressure. We can organize things much more sensibly than in-person hearings. And the second point I wanted to highlight again is using this technology. Let's not kid ourselves. This is all brought about because of the pandemic. We would never be thinking in these terms if we were still operating as we were 6 months ago. But now that we are, I believe our eyes are being opened up to the possibilities of this technology. And we can use the technology in so many more different ways to present our cases, to persuade the tribunal, to show how a case should be broken down. We're just at the tip of the iceberg here, doing calls via Zoom. We will come up, if this continues, and that is a big if, and we'll come back to that as to whether it happens in practice. We will see this technology develop, and we will have more graphical representations of cases. We will have different ways of presenting online. It will all develop in a very, very positive way. So, I mean, the short answer to your question was, I believe every single case can operate through this means. I think at the moment, perhaps cases which are more focused on legal points would benefit particularly and are most adaptable. But as the technology develops, I can't see any reason why we couldn't do the biggest cases out there through a virtual arbitration.
Thank you so much, Mr. Giaretta. And I think the thrust of a lot of what is coming across is the technology that is at play, really. And as Professor Balyan was emphasizing at the start, that's often a huge mental barrier. So, Mr. Mahendra, given your experience with the Center for Online Resolution of Disputes, CORD, what could you tell some of our viewers who are not familiar with this process? what technology is being used, and as Mr. Giaretta is saying, how to best employ it to make the most of the process and the technology.
Sure. Thanks, Aditya, and thank you also for the very kind introduction, Natasha. I will wear one of those hats while answering this question. In the last couple of weeks, 3 weeks, we have seen a whole range of arbitrations, and we have been extremely optimistic about how this can continue due all of the feedback we've received. It's not that only younger arbitration practitioners have started using it. In fact, we've had retired Chief Justices of India, we've had extremely senior advocates start using platforms such as ours and do it at ease. Maybe there's a little bit of hesitation in the first 15 minutes, half an hour. But if you do a test run and they just get used to that process, it becomes extremely smooth and simple. And people, in fact, stop even realizing that they're in a virtual arbitration setting. Now, what are the tools available? In an online arbitration, you can have a whole range of them, starting from e-filing to all the way, digital signatures and digital awards being given. And one big component of it is the virtual hearings themselves. So maybe for this webinar, I'll focus on the virtual hearings because there's enough to speak about that itself. In the virtual hearings, you will have, of course, your video conferencing, which I think people are used to. People are used to Zoom, WebEx, MS Teams, etc. But I think they're limiting in that there's so much more that you can do with something a little bit more tailor-made. For instance, people usually ask me, if I am a briefing counsel and I'm briefing a senior advocate, how do I use a virtual hearing effectively? People say, if I want to confront a witness with a document, but I also want to share the document with them, but not so much in advance. So how do I, come across doing that like you would in an offline setting? Or sometimes people say, I'm an arbitral tribunal. I need to confer between myself to ensure that, I'm not giving out just as a precedent, taking over and sabotaging the entire proceedings. These are things that are possible in a virtual arbitration setting right now. There are tools and platforms available which allow you to have breakout rooms, which enable you not just to have that, chat conversation or a WhatsApp conversation, which people sometimes resort to in parallel to virtual hearings, but you can in fact even have a parallel video conference. So you can have that quick tidbit that is exchanged between briefing counsel and the arguing counsel. You can have hearing rooms where you exchange documents, you exchange messages, etc., so that you are not limited to going back, sending it either by hard copy or sending it by email, etc., waiting for it to arrive, doing all of that real time. Screen sharing is another feature which most video conferencing platforms provide, which I think is an excellent tool, because if you looked at offline arbitrations traditionally, a lot of time went with the tribunal coming to the same page as you, going to the same paragraph. But now with using simple things like screen share, you can bring about far greater efficiencies in the process. You also have the ability to audio video record hearings and also transcribe them. Now that is a little bit of a double-edged sword. Some people like it because there's a little bit more accountability and predictability, but some people are still very cautious because they're not used to everything they're seeing being recorded, and especially in the Indian arbitration setting. And I mean, having dealt with a few international and Indian ones, I know that when the same advocate goes to a SIAC arbitration and argues, they're far better prepared. So they are absolutely okay with it being real-time transcribed. But the same arbitrator counsel doing it in an Indian arbitration is a little bit more reluctant. But I guess that over the course of time will change. But these are tools that are available to ensure that you can make the process more efficient, and tools that also bring about a greater degree of accountability in the entire process. I think this is, in one of those senses, it's a blessing in disguise in that it's bringing about a far-reaching change, although in the guise of a pandemic.
Thank you so much, sir. That's quite a detailed analysis of the technology at play. But I'd like to redirect to Mr. Jain about some more fundamental apprehensions that are being faced by clients, counsel, and tribunal with regard to not having that proximity, that physical proximity. Mr. Jain, is this something that you've been facing with clients, with colleagues, whether members of tribunal or counsel?
Thanks, Aditya. Yes, in fact, there are certainly apprehensions, and I would attribute them to resistance of change. But the issues, I think, are more psychosomatic than actual issues. And as Vikas said, my personal experiences, in fact, I have a 2-day hearing starting tomorrow, absolutely virtual. So, as a tribunal and counsels and parties, it's important to have a very fair and frank discussion before a hearing is conducted, and the trick is in the detail. Your procedural orders, which are issued by the tribunal, need to be extremely detailed in terms of the platform you're using, in terms of your system requirements, in terms of how exactly witnesses would be examined, how the tribunal will make sure that witnesses do not have people around. This guide addresses that issue. One important part is that your hearing bundles need to be very, very properly documented. So how exactly this is being overcome in practice is through mock sessions. Before the final date of hearings, there are 2 to 3 mock sessions where the arbitrators, counsels, parties, witnesses, transcribers, translators, if any, they all come together, they test their systems, people get comfortable with the features, tribunals make sure that the technology is correctly in play. I personally felt that once that happens, everyone becomes very comfortable, and eventually during the hearing, people in fact forget that they are in a virtual hearing, and it becomes much more inclusive, because you're sitting in the comfort of your office. You have everyone there up on the screen. You have your breakout rooms. You have your documents. So I think I don't see any real issue in virtual arbitrations. People will really, really get used to it very quickly.
Thank you so much, Mr. Jain. Mr. Giaretta, while what I gather from Mr. Jain's comment is that the experience allows people to start getting more familiar with the process. My question is with regard to clients at the outset posing some kind of reluctance or wanting to have the best opportunity or to put the best foot forward, and feeling this insecurity that physical proximity might deprive them of that opportunity. Is that something that you experience, and how do you handle that really?
Yes, I mean, that's a very good point. I think there is some insecurity about this. There's a sort of credibility gap that clients, lawyers, arbitrators see people on screen and don't feel it's truly real. When you're sitting in an arbitration room and you have a row of lawyers along the table, and a row of arbitrators and people on the other side of the room, you feel that's real. Whereas here, looking at the screen, looking at lots of different environments, looking at lots of different faces, there's a sense of unreality about it. But people will adapt, people will get used to it. So that will come. And the more that people participate in these hearings, the more that people participate in webinars, the more accustomed they will be to the whole environment. There are 3 other factors I wanted to mention here as well. One is exceptionalism. People always feel or want to feel that they are different from everyone else. People want to say, our matter, our case is different from everyone else. All those other cases can go and do virtual hearings, use the technology, but ours is different in some way. I am different in some way. I want to be treated differently. So let's do it in person. That's a very important factor. That'll be a major reason why people will shift back to in-person hearings later on. But it's not a very good reason, because if you look at it dispassionately, you'll find actually it can all be done online. The second reason I wanted to mention is personal interest. A lot of lawyers, and let's be frank, this is about the lawyers selling the technology and selling the environment to their clients. A lot of lawyers have built their reputation on standing up in court or appearing at in-person hearings, and they will feel anxious. They may lose their standing by shifting to online methods and virtual arbitrations. There will be many lawyers, of course, who will be perfectly comfortable with it, and many lawyers who will feel very, very confident about shifting, but others won't, and that will be a major factor why people will shift back to in-person hearings when we get out of this pandemic. And the final reason I wanted to mention, final fact I wanted to mention was sheer irrationality. people are afraid of what's new. They're afraid of the unknown. And that's really, I think, the major reason why we haven't been adopting this to date. I mean, all this technology has been around for a long time. And it's only because we're now being forced to use it that we're finding actually it works. Actually, we can do these things. Well, that is getting over that fear of the unknown. So to all these factors, I say, it's just familiarity. And I very much echo what Vikas said, that all this technology, that it's just tools that we can use. And the more comfortable we are with using those tools, the better it will go, and the happier everyone will be about using this form of arbitration.
So, I mean, as I see it, there are obviously a lot of apprehension surrounding virtual arbitrations, and we have certain tools to alleviate them, be it the technology. But I think, Ms. Mathur, you will agree that arbitration in particular is probably best suited to such innovation because of the flexibility offered. So how do you suggest tribunals can make use of the flexibility offered by arbitrations to modify procedure and for virtual arbitrations, probably a greater reliance on written submissions or shorter hearings?
Thank you, Natasha. So I agree with you that I think arbitrations do provide a very lucrative playground in that sense to try and experiment with procedure as opposed to courts. And even in the domestic space, even before COVID, the domestic arbitrations were lagging behind in terms of conducting efficient arbitrations as opposed to the international arbitrations. And there were a lot of practitioners and legal experts who, gave a lot of suggestions as well as methods that could be adopted by tribunals to conduct a fair and an efficient arbitration. So in that sense, there is a lot of data that's already available for arbitrators to adopt in the COVID space. The one change that has happened today is that there is a willingness to change. I think that is crucial from all the players, including the arbitrators. Like Ben rightly said, they're forced to now adopt and think of new methods. And in a way, this is the best time to try and implement a lot of practices which are already prevalent in the international space into the domestic sector, as well as come up with new methods to deal with a completely virtual hearing. So, for example, if you look at the initial procedural hearings, which just set the entire timetable. Now, there is no need to have a physical hearing for that purpose. And internationally, tribunals are pretty comfortable with having telephonic conferences for procedural orders. This process now can be adopted for all arbitrations, all virtual arbitrations, pretty seamlessly. Discovery is another aspect which was handled electronically by international tribunals. There was no need to meet. The red phone schedule is again a very well accepted practice whereby arbitrators can decide on which documents to be produced or not. And here also they can exercise discretion in limiting disclosure of documents and curtailing this process pretty early on to increase efficiency. So to my mind, I think two main areas where there will be a drastic shift in perception as well as practice will one be in the evidentiary hearings. The second will be in final arguments. Now, the rest of it, pleadings, written submissions, all of them have always been, for the last 5-7 years, been exchanged electronically. So I don't see a change there. But you're right, there is a perception that unless the witness is in front of the tribunal will not be able to gauge the body language and will not be able to really appreciate the effect and impact of the cross-examination. So I completely agree with the views, of my esteemed panelists, where they say that there's really no need for a physical hearing for conducting evidence hearings as well. And any arbitrator will be able to gauge the witness behavior and the body language even on screen. There are certain precautions that certainly need to be taken, and Samir referred to them. You basically need to educate parties a bit more about conduct. So there needs to be mock sessions. There need to be, directions given by the tribunal. The witnesses cannot be coached. They need to be alone in a room. So these are kind of, logistical issues that the tribunal needs to think through. There are also issues on data protection that the tribunal needs to think through, which it had not done in the past, because now with everything moving virtually, they need to ensure that there's no leakage of any form of data, including financial matters, intellectual property, personal information. And there are protocols that have been developed in the international space. Your guide very helpfully refers to the the ICA NYC VAR and the CPR cybersecurity protocol, which whereby arbitrators should have a dialogue with the participants, with the legal representatives, as well as clients early on, about protection of the information and the manner in which that will be ensured. What are the repercussions if there is a data breach? And as well as setting down guidelines about document storage, document transmission, live hearings, the audio and the visual aspect. And I think these things will sort of fall in place with time and with practice. And as more and more arbitrations are conducted in the virtual space, certainly a lot of these issues will get ironed out, but arbitrators do need to know about issues such as information breach as well.
I recall you sharing a Delhi High Court order with us at the time of the review, where the High Court had suggested an asymmetric proceeding, where video arguments taken on videos were to be shared between the parties and at different times, and then a short reply be given to each. So do you see?
I think, yeah, you're right. I think in terms of the arbitration space, it's more likely that arbitrators will conduct synchronized hearings as opposed to asynchronized hearings, because once the system is set, if you have a good tool, a good technology platform, and parties obviously will be saving costs in physical hearings. So that cost can then be attributed to investment in a really good platform. Then if there is a recording of the hearing, then maybe the arbitrators may not insist so much on video clippings of written submissions, the way the Delhi High Court had come about. But again, I mean, it depends on cases and depends on arbitrators. If they feel that it would benefit them to also have a video clip of the submissions post the hearing, that is also something that they can build in. So while I do think that asynchronized hearings would probably is something that courts should definitely follow, the way the Delhi High Court did in the June 1 order. However, it could be adopted in the arbitration space as well.
Mr. Khambata, could you share with us, as an arbitrator, what other tools do you think an arbitrator has to get creative and innovate proceedings that are best suited for and tailor-made for virtual arbitrations?
The tools have always been there. And it's just, as Vikas told us, the technology is out there. We haven't been using it. This is a crisis. It's like learning how to swim. There's a fear of getting into the water for the first time, but suddenly when you're in there and you flap about and you realize you're floating, you realize you can do it. So it's a lot of arbitrators themselves fear the technology. And I think the more they do it, the more comfortable they're going to be with it. In India particularly, and I won't say this just from the perspective of an arbitrator, but even for practicing lawyers, I think there are three areas that strike terror in the heart of lawyers at least, but they won't, of course, admit it. The first is the emphasis on the written word. We are brought up in the oral tradition, and we are more comfortable orally persuading a tribunal rather than putting it all down cogently in writing in advance. In international arbitration, that has actually never been the case. You've always had to put things down in a very focused way. And I think with virtual hearings, you need to put more in writing because you need to ensure that there's more preparation. You need to ensure that the tribunal is actually looking at something and following you and has read something even before you've argued, because concentration spans are not as good on screen as they would be in a physical room. So that's the one area. The second area is which also is something that is feared by us in India, is time limits. We do not know often how to adhere to time limits. It's actually one of the most important things. I remember reading a poll once, a poll taken of 5 or 10 leading arbitrators in the world. And they were asked, what are the 3 things that you love most about counsel and the way they practice, and the 3 things you hate most? And at the top of both those lists, the overwhelming majority said they liked a counsel who kept within time limits. And what they hated most was a counsel who didn't adhere to time limits. So that's another area where we'll have to now discipline ourselves. And the third area is trolling through an e-brief, e-bundles, as Samir was talking about. It's actually not that difficult. I've been doing it in arbitrations, and now I've had to do it even in virtual court hearings the last 3 months. If you learn how to organize yourself, and you can teach yourself this very easily with proper bookmarking and things like that, you can actually be probably more effective using an e-brief than you were with the volumes, with the 35 volumes of documents. It's probably quicker to have an e-brief if it's properly bookmarked and you're familiar with it. There is one remarkable technology that's been there for years. Sonali will remember we did an arbitration together years ago, where in addition to real-time transcription, there was also the Opus Magnum technology, that was a very fact-heavy arbitration. There was, I think, 30 or 40 bundles of documents, more maybe. And rather than the tribunal and individual lawyers sort of clicking through their laptops and pulling up documents on screen, we had the facility of a technician in the room dedicated to putting that document up on everyone's screen simultaneously the moment you mentioned the bundle number and the exhibit number. And you could even go down to the page of the exhibit. And that made it so easy because you just had to say that. And it was, here presto, it was there on your screen. Now, in India, where skilled technology is not that expensive, I don't see why we can't have a technician dedicated to a virtual hearing in an arbitration doing precisely that. I doubt whether the technology is that complex. And you can just have someone doing a more institutionalized version of screen sharing effectively, but someone else doing it for you. So we've got to think of new ways of using the existing technology to make it more palatable and easier, particularly for Indian domestic arbitration, to be able to feel they can live with this technology and maybe even harness it to be more effective and more productive. And I think one of the best ways, and I agree with Ben, is I think the MNLU the Guide to Virtual Arbitration is a remarkable document. I've gone through it. I think it should be compulsory reading for anyone who wants to do a virtual hearing, even if in court. I think 80% of it works even for court hearings. It's beautifully crafted. It's well thought through. It's simple to read. And I think if you just go through that, you'll realize it's not that difficult. So yes, there are going to be problems. Confidentiality is the obvious big issue. We have to work around that. There's the psychological problem of evidentiary hearings and cross-examination, because you like eye contact with the witness you're cross-examining. But then again, in India, we tend to forget that in court hearings, we haven't had physical cross-examination in court for years. It's always before a commissioner. So the issue of the tribunal not witnessing the witness's demeanor has been a non-issue in Indian courts for years. So if it can be a non-issue in our courts, there's no reason why in arbitration you can't have a similar practice. I'm not at all suggesting that virtual hearings eliminate the tribunal witnessing the demeanor, because in fact, it's a nice intermediate where you can see the witness and the cross-examination can go on. You don't have to be in the same room as the witness. And there are ways of protecting the sanctity and the integrity of the process. That's fairly simple. So again, I think it's overplayed to say that evidentiary hearings are more difficult. I think it's a matter of getting down and doing them. And once we start doing things, I think people will be very comfortable with remote hearings even long after the pandemic is over.
Thank you, Mr. Khambata, and thank you so much for your kind words about our guide. It was a humble attempt by Aditya and I and Professor Chirag, and we're very happy that it has been found useful. My next question actually is to Mr. Vikas Mahendra. I mean, we've been talking about a lot of apprehensions that party might have, and some might be legitimate and some might just be a dilatory tactic. So in the event that one party objects to a virtual hearing, whereas the other party requests it, do you believe that the tribunal has the power to compel a virtual arbitration?
Natasha, thank you. I think that question in theory is a yes, because an arbitral tribunal has great procedural flexibility to cater to an arbitration in a manner that it deems appropriate. But in practice, whether it's in domestic or international arbitration, a tribunal will rarely go against what a party would expressly object to, especially if one party is objecting to it vehemently and there is some basis to it. For instance, if they say that I'm not technologically savvy, I don't see an arbitral tribunal come down and say, no, absolutely not, you have to do it. What they will probably do is try and come up with some sort of a midway ground. And I think there are ways and means of achieving it. So for instance, a tribunal can very well say, okay, listen, if you're not familiar, why don't I postpone the hearing by, let's say, 2 or 3 weeks? We'll try and set you up with one of these institutions where you can use the platform and let us know if you've gotten comfortable during this process. And why don't you report back? And then we'll see how to take it forward. Maybe some midway ground where they will try and cater to those interests. But I don't think a tribunal will be so adamant that he'll say, no, absolutely not, you have to go ahead with this. And in fact, I'll give you an example of a hearing that happened recently on our platform, where one of the parties objected to a cross-examination on a virtual hearing. They said, I'm not going to do it, I'm not going to be comfortable. The tribunal tried telling them that, listen, it's not going to be that much of an issue because, like Mr. Khambata was saying, it's not really that different from what you would do in an offline world. And in fact, if you take even offline arbitration, demeanor of a witness is probably the least of your worries because all of them are focused on that projector screen. No one's really looking at the witness. Everyone's looking at the projector screen. Is the question coming up properly? Is the answer coming up properly? So that way, it's just a replication of that in people sitting in different places. But after a point in time, the tribunal felt that with great reluctance, if I still push ahead with it, there is a risk that the party might go ahead and challenge this at some point in time. So they said, you know what, why don't we then pause for another month or so? Let's see if the situation improves. If it doesn't improve, we will revisit this issue. So I think it will then become a cost balancing. If it delays an arbitration too much, the tribunal might persuade the parties a little bit more. But I think if there is an objection, the tribunal will be a little reluctant before imposing it on the parties.
Thank you, Mr. Mahendra. So, Mr. Jain, as I understand, there are obviously situations where there might be a legitimate reason for a party to object, and there are certain factors. In your experience, why would you think a party would object to a virtual hearing? And additionally, I think this objection probably stems from the right to an in-person physical hearing. Do you believe that such a right exists in arbitration?
Thanks, Natasha. So to answer the second question first, in my view, no. There is no right per se for a physical hearing. There is no provision in any of the international institutions' rules or under the Act. Yes, you have a right to a hearing. Principles of natural justice must be followed. Why there is an apprehension for people who genuinely want to object has been answered, I think, in quite a detailed submission by everyone. What I feel is that the mode and manner of the hearing is a procedural issue. The tribunal, as Vikas said, is well within its power to devise its procedure. In fact, if you were to see the rules of the 3-4 major institutes, for example, Article 14 in the LCI rules, 19 in SIAC, and 22 in ICC, it in fact mandates that the tribunal must devise its procedure around and in relation to the circumstances which are prevailing. So if you take the current circumstances which are prevailing around the world, we don't see physical hearings and travel getting allowed anytime in the near future. So if the situation before the tribunal is such that if they were to postpone it by a couple of weeks and a physical hearing would have been possible, yes, maybe then it might be a valid objection. But in a situation like now, when no one knows when a physical hearing would be possible, it would be in fact a due process issue if the tribunal does not adopt a procedure which is in fact suited to the circumstances. So if you must also have a read to the Jaguar case, the 2020 Singapore Courts of Appeal case, where the extent of right of natural justice was discussed in an arbitration scenario. And the court said that natural justice right is not an absolute right. And there's nothing different you could have done in a physical hearing than you could not do in a virtual hearing. So I don't think that an objection like that would be a very tenable objection if someone was to challenge in a vote on that basis, provided that all the, there was no actual impediment in terms of the hearing. For example, if the connection was not proper and a witness couldn't be examined properly, or the final arguments could not be rendered properly, then maybe yes. But if all the prerequisites as we've discussed in the past, previous 30, 40 minutes are followed, then I don't think there would be any valid challenge to an award.
Thank you so much. Natasha briefly mentioned dilatory tactics and what has been earlier recognized by the panel as the devious part of virtual arbitration. I redirect to Mr. Giaretta on what exactly the importance of good faith is in this context. What if, for instance, a party were to feign a loss of connection at a crucial point in questioning? Doesn't this raise issues of ethics and good faith? And doesn't this idea of good faith take on a whole new importance now?
Yes, so virtual arbitration is a system, and people will always try to game the system. Virtual arbitration gives a participant various control over the environment, and some people will try to use that control in order to advance their position, advance their arguments. Most obviously, if there's a point that they are having difficulty with, perhaps they will pretend that they have a bad connection. Perhaps they will turn down the volume or turn up the volume. I mean, there's a whole bunch of things that they could do. But let's not forget that in an in-person hearing, similarly, people game the system. I have sat in arbitrations where my opposing counsel has got up and walked out. I have sat in in-person hearings where my opposing counsel has almost pretended to fall asleep or pretended to made faces at me across the table. There are all sorts of different things that people do currently in in-person hearings. And that behavior will continue in a slightly different format in virtual arbitration hearings. And you're quite right that people have to approach this in good faith. That's an important part of arbitration, but that's true currently in in-person hearings just as much as it will be in virtual hearings. And also, let's not forget, actually the vast majority of people will try to approach it in good faith, legitimately, and will try to adapt. And also, arbitrators, the more experience they have in these hearings, the more they'll be able to spot people playing games. When I have sat as an arbitrator, it's obvious sometimes where people are playing games, and arbitrators will learn that in this virtual environment as well. So the question is a good one, but I don't see it as an obstacle to the use of virtual arbitration. It just means, as I've said several times already, we will have to adapt, and we will adapt as we get more experienced.
Thank you. Ms. Mathur, what are your views on procedural good faith, and specifically in the Indian context, do you see this playing out a little differently?
So I do think that there is only limited value in a party trying to adopt any dilatory tactic. Any arbitrator, with experience will be able to see through such tactics, and they cannot be repeated. So there will be adverse inferences that an arbitration tribunal will draw on a party that's not cooperating, and it's visible that they're not doing so in good faith. Under the Arbitration Act, I think the arbitrators will need to be a little cautious of certain provisions. For example, Section 18 does say that, full opportunity should be provided to both the parties to present their case. And even under Section 34, one of the grounds for challenge is that a party was unable to present their case. In the context of 48 as well, to resist enforcement of a foreign award, there may be instances where a party may raise this issue. So the arbitrators, I think, in the process need to be a little careful. Since anyways there is saving of time in an online process, they can halt the hearing if there is a connectivity issue at one end, and probably reschedule it as well. It may not be that difficult to reschedule hearings or conduct it after some time if there are issues, as opposed to a physical hearing and rearranging things and booking venues. So there are certain things that the arbitrators do need to keep in mind. They need to record the consent of parties upfront. That's also very crucial, that the parties are upfront in writing, recording that they are agreeable to the virtual hearing, so that later on they do not raise any issues. Even earlier I mentioned, for data protection and data security, agreements can be entered into with the parties upfront in the first case management hearing itself, where detailed guidelines are laid down and parties agree on how data transmission will be done, how documents will be stored. And I think if a lot of this is put in writing, it limits the ability of parties to then raise frivolous arguments later or to act in bad faith. And if they still continue to do so, then there is the danger of an adverse inference against them.
Thank you so much. There's one last question that I had for Mr. Khambata, which I was slightly reluctant to ask, given that it seemed that he had already answered most of it. But I'm not going to give up this opportunity to ask him on advocacy. And therefore, my question to you, sir, is how do you think that counsel should alter their advocacy strategies? You said in the beginning that focus on the basics. What, according to you, is the basics that need to be really hit on the head?
The basic has always been fashioning a concise and clear written argument. It's always useful, even if you're in the oral tradition, putting your argument down in writing, because the moment you do that, you'll realize there are some things you just cannot push, and you'll drop them, you'll focus your argument, and you'll make it more concise and therefore more effective. That becomes all the more important in a virtual world, because you've got to give that focused written submission to the tribunal for them to use and for them to navigate through the morass of documents, volumes, and law. So I think the basics is the written word. It will now rule the oral word.
Thank you.
I think you're on mute, Natasha.
I apologize. I think we've had a very optimistic panel today, and I think that's really promising, especially for Aditya and I, the future that we're entering into as young lawyers. But the question that I have, the final question for all the panelists, is something that I also have for all the audience members. What does the future look like? I think that is what is going to take us full circle. Do we see, I think it's mostly been answered, but if we could just have some concluding remarks on that. If Aditya could just bring the poll link first so our audience could participate. So will virtual arbitration be accepted as a regular practice in India, even beyond the current pandemic? If we could have some concluding remarks by all our panelists. Mr. Khambata?
It will, because long after the pandemic goes, the earlier problems will still remain. Scarcity of time, scarcity of money, scarcity of resources, scarcity of space. They were always there. And the solutions we've been discussing today will work equally well to address those issues. Good faith cooperation, etiquette, discipline, written word, no ambushing of one's opponent. These are all things that will inure to the good in the future, with or without a pandemic. So the future is a better world, to my mind. It's the change we want to see, as Gandhiji said. And I think all of us have to contribute to that.
Mr. Jain?
My view is yes, again, because I think it's one aspect you need to see about virtual hearings is it also saves a lot of cost. You don't have to travel, you don't have to spend money in stays, you don't have to book physical centers. The cost for online hearing centers is lesser than physical. So yes, there's cost saving. I personally feel this is more efficient than physical hearings. The change of strategy, as Mr. Khambata said, Counsel would have already gotten used to that. In strictly Indian context, I need to add that apart from the willingness of the Counsel's parties and the tribunal, the infrastructure needs to improve as well. There needs to be proper high-speed internet connections available to everyone. You don't know where your witness is located. So subject to that taking place, I think the future looks bright for virtual arbitration. Thank you.
Mr. Giaretta?
Thank you. Well, it partly depends, I'm afraid to say, it partly depends on how long the current situation goes on for. Now, if the pandemic continues for the next year, that will be terrible in terms of the health impact of the society impact. But actually, ironically enough, it'll be very good for virtual arbitration because we'll all become very, very used to it. But however long this situation goes on for, I think it will maintain, virtual arbitration will continue to be an important part of arbitration. Personally, I would say that every hearing should be done by virtual arbitration, 100% of hearings. Now, as a realist, I would say that's not going to happen. There are powerful enough forces to get people back into arbitration hearing rooms, courtrooms in the future. But I still think that a substantial proportion of hearings, I don't know, perhaps 50% of hearings will be done by way of virtual arbitrations after this, because people will see the advantages.
Thank you. Mr. Mahendra?
I agree with everything that's already been said, but I think there are a couple of challenges which we will face, and it's about how successfully we're able to overcome them. First, I think, for better or worse, there is a lobby. There is a lobby of existing practitioners who have much to gain by conducting hearings in person. It may be that they're able to charge a little bit more for in-person hearings. It may be that there are, they can reimburse their travel, they can reimburse entire days for hearings. There are things that are financially playing a part in all of this. And these are people who are able to convince their counsel that, listen, it is actually really important for you to have an in-person hearing, maybe for a very personal, slightly perverse logic that, I will make a little bit more money out of it. And then we can't ignore the fact that there are such people. The question is whether the clients will now start getting educated enough that they can see through it. Now, if businesses, like Ben was saying, if they see enough hearings which are successfully conducted virtually, they may be able to overcome those things. But I think that is a barrier that exists, which is real, which will have to be overcome at some point in time or the other. But I think in terms of a technological awareness, this pandemic has been an eye-opener for a lot of people, and they're starting to realize that it is possible, especially in India, when a lot of your arbitrators are, whether you like it or not, beyond the age of 60, 65, 70. They will probably start getting a little bit more conscious about what are the risks and perils of actually traveling to these hearings. Even if the pandemic goes, these risks will are always going to be there. So I think that will move us in a direction of becoming more virtual, but I think we have to overcome that lobby at some point in time.
Ms. Mathur?
Well, I do share your optimistic note about virtual arbitration, Natasha. I do think that our lives have changed forever, and we're never going back to the life that we had pre-COVID. So in that sense, there is no more awareness today of a new method and a more efficient way of conducting arbitrations. And I think that will stick. There may be fewer in-person hearings. There may be certain cases which, do demand that a personal hearing is required, but there'll be very few. So most of the cases certainly will be conducted virtually, which again does require a lot of commitment, effort, and a lot of technological support, in order to be able to get an efficient process. So, but these things are still something that I am positive about, that will just iron themselves out. Any wrinkles will iron themselves out as things move along.
So while the pandemic has definitely paved the way for a much more promising future for virtual arbitrations, it has certainly robbed us of the opportunity of sharing a cup of tea with all of you. But with that, I think we have a lot of questions from our viewers, and I think we can answer a few before we conclude. I think the question that is most repeated here is that of witness coaching and cross-examination and witness tutoring. So a lot of our viewers are concerned about whether how to ensure that a witness is not being tutored. Mr. Mahendra, do you think you could help us with that?
Yeah, Natasha, thank you for pushing that question. You'll remember that we had this exact conversation when we were reviewing the guide, right? And there's a couple of solutions that we as an online resolution institution have devised, and a couple which existed from previously. Things like an observer in the room have been practices that have existed forever. So for instance, if you have a witness who's, let's say, in the United States and you have everyone else in Bombay, then instead of getting that person in, what sometimes people did was have an observer in that room. That addresses a lot of questions. For instance, the issues of bad faith, poor internet connectivity, suddenly, me having to get some other problem, coaching the witnesses addressed to a large extent if there is a person physically present. Even if that is not possible, there are a couple of solutions that technology offers. For instance, if you get the witness to share their screen, you know that no messaging is coming in from the screen. The second solution, which at least us offer, is dual logins, which means that you can have two devices logging in using the same user ID. So that way you have two cameras monitoring, one, the environment of a witness, the other, the witness's answer itself. Now, others have produced, they have other solutions like a 360-degree camera, etc., which requires a lot more technological intervention. But I think even with existing simple technology, it's possible to achieve it to a large extent. Now, if you have people like, someone like a Munna Bhai MBBS person who has something embedded into his ear, which is playing, you can't do anything. You can't do anything in a physical world. You cannot do anything in a virtual world. But I think barring those extreme examples, you can get to a great extent. And I think, in an arbitration as counsel, I have some idea whether a witness is reliable or not. So I can take a call on whether those extreme measures are necessary for that witness, and maybe for that witness have an in-person hearing. So I think those kind of in-between solutions can always be worked out given the procedural flexibility that arbitration has.
Mr. Kamdar, who happens to be an arbitrator, who is one of the viewers here, is conducting a witness cross-examination shortly, and I'm sure what you've said is going to help him. Would anyone like to add? Yes, Mr. Giaretta.
Yes, I think what Vikas has said there is excellent. I think there's a very good tip. Let me just share a very nice low-tech tip as well, which I was told is a fantastic solution, which is to make the witness sit in front of a mirror. So you put like here, there's a mirror on this wall behind me, so that all of you can see the room that I'm sitting in. You'll know if people are sitting there coaching me. You may not need to use, I think the screen sharing tip is an excellent one, but there's another tip for you, to have a mirror on the wall behind you.
The cost of shipping even maybe a concave mirror is probably going to be far, far lesser than any other solution that people might think of.
The next question is, how would you deal with technological inequalities between parties? Would any of the panelists want to volunteer an answer?
Yeah, could I? Yeah, I think actually that is a real issue. That's one of the real issues that will arise, because as long as equal opportunity is given, as we know, that's the threshold requirement for fairness in an arbitration. Strict rules of evidence won't apply. But if you have a case where genuinely one party or a particular witness doesn't have access to the type of technology that is required, I think that will be a challenge. And that might require then deferment of hearings until a physical hearing can be held. Because you really can't, if the cause is genuine, then you can't have one party at a disadvantage merely because they don't have access to the technology that's required.
Yes, Mr. Giaretta.
I think we should bear in mind the various societal changes that are going on, in particular stimulated by the pandemic. One of the things I think will happen more and more is we will have more co-work spaces. So fewer people going into big offices and more using a dispersed system of work hubs throughout the country, throughout the world, in fact. So you may find actually that a party that does not have direct access to the right technology in their own homes, in their own offices, could very easily go to a work hub where they have very good technology, and that may not be very far away. In Britain, we have WeWork in lots of different locations. I'm not sure what you have in India. I think you do have some WeWorks as well. And there'll be further companies like that. So that's a good way of doing it. Plus also a number of arbitration institutions are getting together to offer a system whereby you can just go to your local arbitration center and do the hearing, your component of the hearing from there, rather than doing it from home. So I think there are solutions to the problem you identified.
Natasha, can I ask a follow-up question from Mr. Khambata? Sir, when you talked about access to technology as one of the basic premises for the equal opportunity, I was told that there are some law firms which have very efficient softwares for e-discovery. And then there are advocates who don't have efficient or sophisticated softwares for e-discovery. Does that also create a technology barrier and will create a challenge for equal opportunity?
Not at all. You'll always have lawyers with access to better infrastructure, more capital intensive lawyers firms versus the smaller lawyer. That's not a lack of equality of opportunity. I agree with Ben that in most cases there is access to technology, including in India, where almost every Indian today has a smartphone. And you don't need much more than a smartphone. Yes, ideally you need 2 or 3 devices going simultaneously, but with a couple of devices you can make it work. So as long as you have the threshold technology, that's enough. If someone has better technology or has better research facilities or has larger teams of lawyers, that's not inequality. That inequality has always existed, whether in a virtual hearing or in a physical hearing.
All right, I think we have run out of time now and we'd like to conclude. I'll just put up what has been a fairly promising voter turnout, the results of which are that our panel of experts have convinced the audience that surely virtual arbitrations are the way ahead. Now, before I sign off, I'd just like to thank all our viewers.
Share the poll result.
Oh, did I not? I'm sorry, I myself am acquainting myself with this technology. So that's a 71% yes in what was a very good 90% voter turnout. Anyhow, so before I conclude, I'd like to thank all our viewers for tuning in today and for being a part of our project. We look forward to them tuning in, look forward to all of you tuning in again on the 26th when we'll be having our second webinar of this series. I'd also like to thank the Center for Online Resolution of Disputes, Mr. Kinhal and Mr. Mahendra, who have helped us a lot with setting up this webinar. And the only reason why we've been able to conduct things like the poll and the questions is because of their guidance and support. And lastly, but by no means the least, I thank all our panelists for their support and encouragement. Not only have we had a great engaging discussion today, but the panelists have been our reviewers, and all the praise that we have received from Mr. Khambata today is mostly due to the reviews that we got from our panelists who took time out from their busy schedules to go through our drafts and have long, lengthy phone calls with us discussing those issues at length. So we're very, very grateful. And the Center for Arbitration and Research hopes to continue to have your support and encouragement in the future as well. With that, I hope you all have a great day ahead. Thank you.
Thank you.
Thank you. Thank you. Thanks.
Thank you,
Thanks, everyone.
Bye.
Thank you so much.
Bye.